Good afternoon, and thank you for tuning in today. We wish all our viewers a very happy Independence Day. As we celebrate the 15th of August, we introduce sessions about Indian polity, law, freedom, and basically how we get here. Keeping in line with that tradition, to mark the occasion today, I will be in conversation with the president of the IYEA, Mr. Ajay Sabharwal himself, and we'll be talking about economic freedoms in India. Welcome, sir. Glad to have you here.
Thank you so much, Ria. And
Right.
it's a pleasure to be talking to you today. And it's good that this tradition that we started many years ago of having one podcast dealing with the Indian polity, history, economy, and law of India uh, is continuing. So it's a pleasure. Please.
All right, let's just get right to it. To begin with, let's talk about the ease of doing business. Are we increasing in the ranks? What exactly is your take on that? And how do you generally think the business environment in the country has been shaping up?
Okay. So before I get to ease of doing business in India, I think it's important that I also wish all the viewers very happy Independence Day. सभी को स्वतंत्रता दिवस की हार्दिक शुभकामनाएं. And now getting to your question here, I think over the last few years, India has been rising in the ranks, right? But I don't think that that is producing any necessary material change, any tangible change on the ground as to how businesses operate or how free they are as such. Right? And again, this is not a comment on whether business freedoms have increased or economic freedoms in India have otherwise increased or not. It's just that such indicators by themselves are never entirely accurate of the real position of any country, right? Especially in an environment, and I think this is across the world, where we've reached a point where we look at gaming the indicators rather than comprehensively reviewing the entire situation and creating an environment for businesses to prosper, right? So very often these indices have certain indicators, right? These many days to enforce a contract, these many days to start a company, right? So very often government machinery is across the world, and I don't think India is necessarily alone in this. I think government machinery is across the world because they want to attract investment, they want to increase their at least project an image that they are very business friendly, that they have a lot of economic freedoms. They keep on ticking these boxes. So, okay, this is the period in which we settle commercial suits. This is the period in which you can get registration for so and so company. This is the procedure for incorporation. In this particular timeline, you will be completing your insolvency process. So, all of these things, anyway, get to a point where those timelines may be followed, right? And I'm not saying those timelines aren't necessarily followed, they are followed from time to time. But that by itself, or these ranks only on the basis of these indicators, is not necessarily entirely accurate of whether we have a better environment for economic freedoms in India, right? But irrespective of that, I think even keeping these indicators aside, or at least these indices aside, I think on other grounds, the situation in India is obviously improving, especially if I were to go in the last two odd decades, right? If you were to go from, let's say, 1999, obviously we can go with this since 91 and say, okay, the situation's improved quite a lot. But if I were to specifically say, I would say about 1999 up until now, the situation has improved quite a lot, right? In the last sort of 20 odd years, situation has improved, but that doesn't mean that we are anywhere close to where we should have been by now, right? So obviously, and I'm seeing this not as someone who's necessarily pro business, right? But I'm seeing this as someone who's pro market. Now, there's a distinction that has to be made. Very often, people confuse the two terms. Right? The idea being that when you're initiating reforms and when you're talking about economic freedoms, they go way beyond mere business freedoms. Right? So, that's a distinction that is very necessary. And while business freedoms are an important part of economic freedoms, we must not forget the larger economic freedoms ambit, which gets within it not just business freedoms, but other individual centric freedoms regarding their economic rights. So, even on those parameters, there is a lot of room for improvement. And that's where I think a good chunk of the work should be done in the near future.
Right. Keeping in line with the business environment in India, are there any other significant indicators other than the ease of doing business that perhaps we can look at to gain some concrete ideas about how exactly India's trajectory has been regarding the same?
Okay, indicators per se. Okay, so if you look at some of the indicators which are used within these particular indices themselves, right? Like I said, they are good indicators. I'm just saying that they are not sufficient enough, right? But apart from that, I think first, if you were to sort of begin, and I want to sort of rewind before I get to this point, right? An essential component of economic freedoms is the right to property, right? Or the right to hold property to use it to your benefit. Now, at one point, it used to be a fundamental right. Right? Article 19(1)(f) in its original form gave the right to property, but which was amended. But then you had Article 300A, where the same right was recognized as a constitutional right, but not necessarily as a fundamental right. Right? Again, it's goes beyond mere terminology. But when it comes to enforcing these rights, obviously, the courts have been providing purposive and benefic interpretations so as to protect these rights. Right? So obviously, this I'm just sort of reminding to sort of give a sense to the viewers as to how we sort of have gotten here before I get to indicators specifically. And the key indicator that I would be talking about is the larger sphere of law, right? Within which you have certain rights and how fast that pace moves, right? So one, like I said, was 19(1)(f), which was amended, which no longer is a fundamental right, the right to hold property, which is now under 300A, which is again enforceable the very same way that you go through writ, and if there is any property that is taken over by government which is without the force of law, then obviously you have similar rights which would have been under 19(1)(f) as well. You have another right which is 19(1)(g), right, which is your right to engage in a particular profession, trade, business, so on and so forth. Right? Obviously, this is subject to certain limitations, certain restrictions which have to be reasonable under 19(6), and which include, for example, if I want to today be a doctor, I can say I want to be a doctor. It's my freedom to be part of this. It's my right to have to participate in this profession. Right? There are certain technical norms which I have to follow, and it is such restrictions which are also necessary for the growth of that profession. So those restrictions are obviously there. When it comes to businesses, there are other indicators such as there are other restrictions such as there might not be a fundamental right if someone wants to sell alcohol or trade in alcohol, right? Or tobacco, right? So there are certain, or let's say gambling, or let's say carry out sort of state or lotteries, so on and so forth. Again, this we've had earlier discussion on state and private lottery and all of that. But there are restrictions on such certain industries or such enterprises. This is the larger sort of environment when it comes to at least how the constitution protects uh, the rights not just to indulge in a profession, not just to participate in a profession or to have business, but also to hold property. So broader concept of economic rights. Obviously, like I said, they are subject to the other restrictions which are there in the constitutional framework. And as we progressed over the years, obviously the indicators, and I said I'll be talking primarily on the lines of how the legal framework has developed, right? So earlier we used to have the Land Acquisition Act, right? Which again, there's a lot of legacy litigation which still goes on in this context, right? The key question ultimately was, okay, how do you determine the kind of compensation that is just or reasonable and fair? Right? Ultimately, that's what it comes down to, because if you still go with the um, with the assumption that, okay, there will be a necessity for state, by state I mean here the government or the government machinery, to take over land for public purposes, right? Which in any country in the world, which we call eminent domain, right? When the government takes over land, right, for a public purpose, that will be there in any country in the world. But what is the key question is to how you are compensated, how fast you're compensated, how much are you compensated? Is it possible today for someone whose property was taken over 30, 40 years ago, who's still sort of litigating to get a higher compensation, which that person believes to be fair, and the compensation they're provided by the government, which is not fair, which is peanuts as compared to what would have otherwise been the market rate, or in fact, for that matter, should have been even higher than the market rate in some places, because, well, at times governments will take over when the market is not ripe for at least producing the right prices, and let's say it's through a recession or it's through a time period where the interest rates are very high and the property rates are very low, so on and so forth, right? So, but they don't want to even sell at that point. They're, let's say, saving for a particular day where they would get a better price. So would market rates suffice in those particular situations? Absolutely not, right? So what I'm getting to here is that when we talk about property rights specifically, right, sure, the governments have been taking over land. And then we had the Land Acquisition Act, which was then replaced in 2013 by the new act that was brought in, right? The Right to Fair Compensation Act, which brought in changes, right? Again, we still have to see, because, like I said, even today, the litigation that is pending is for the Land Acquisition Act, or the old act. Right? So if that is still going on till date, right, which is, again, many of them are still in high courts, so across the country. So by the time that litigation ultimately finishes, it's going to be sort of maybe 30, 40 years after the land was first taken over in many places. And are you to say that in that same area where now properties are worth hundreds of crores of rupees, the government would be willing to, or in fact, for that matter, would courts be even be willing to award that kind of compensation today? Or keep that aside, would the person who's lost their land in that particular area be able to, with that compensation that he's gotten, be able to get similar kind of place to stay? Probably not, right? It's likely that that's not going to be the case at all. And that's why I said that indicators by themselves, right, we're moving in a good direction, absolutely. But mere indicators are never going to be enough for us to say, okay, fine, we have a good environment, right? Why? Because there is also a particular distrust when we say, right, again, this is more societal, and we very often don't touch upon such areas, but when it comes to economic rights and just looking at businesses, there's a sense of distrust, which I think is absolutely misplaced, right? Sure, we have a few rotten apples every now and then, but overall Indian society, the mindset of the bureaucracy has to sort of get better, right? We can't always say, okay, if it's a business, if they're making money, there's obviously something wrong with it, right? That possibly cannot be the mindset. I think if an indicator, if you're looking at a genuine indicator, at least from my point of view, I think if that is the key thing, once that changes, I think we'll be in a very good position, but I don't see that happening anytime soon. At the same time, again, we're on the question of sort of property, and I've said this very often earlier, that in places like the United States, right, where you have similar rights, right to property, it won't be taken away without the due process of law, and you would have the legislation passed by the House of Congress, so on and so forth, much as we have it here. But what we see, and the key difference that I see in India and in other places, is that, again, I don't want to make a normative statement here, but just, you could say that's more of a general statement that I'm making here, is that in places like the United States, very often such legislation or such rights protect those who are already well off in terms of their economic standing in society in comparison to the rest of the country. But in India specifically, I'm basing this on my limited experience, that more often than not, groups that lose out on their property and their rights and not get adequate compensation as a result are those, number one, which are in rural parts of the country. right? At the same time, again, I think it's also important to make a distinction between rural India and not economically as privileged groups. There has to be a distinction that has to be made here, right? One often people indulge in this position that okay, fine, if it's rural, it necessarily has to be poor, right? So that's also a distinction that has to be made here. But yes, in India, it is those people with perhaps who are in the rural areas, right? Number one, obviously, because the land acquisition in sort of urban centers is obviously also going down as we are going ahead in the timeline of the history of this country, right? But at the same time, it's also those groups which are not economically well off already, where it goes beyond an element of coercion, right? Where you have at the local level, very often people complain that we had certain properties and then before the government took it over and gave it to particular private interests to maybe set up industry or universities and so on and so forth. Seen this a lot in sort of the areas neighboring Delhi, right? Whether it's Punjab, Haryana, UP side, right? All of these areas. And this is not today. This is for over a decade here, and maybe even more, few decades in fact, that before the land is taken over, you see the state machinery sort of cutting off utilities, cutting off water, cutting off electricity. What happens? The person who is not even wanting to sell is often frustrated, right? And so it becomes more of a compulsion where we see that it's always sort of these third parties, which are not otherwise the state, but they're very closely related to these state actors who get the benefit out of this. Who would be the ultimate sellers to the government, where you could see, okay, fine, there is a sufficient amount of expenditure that goes into purchasing this, but the original bona fide owner does not get the entire benefit of that, right? So that also becomes a very, very important issue in these contexts. But having said that, like I said, short the numbers game is important, but it's not sufficient. Post, let's say, the land acquisition, this is one part because I think right to property is a very often forgotten, important right in this country. So that's why I sort of emphasized on that first. But even apart from that, when we talk about sort of business freedoms, I think the first part is enforcement of contracts. Right? Now, the Indian law is very simple, right? It's not very complex, and it's primarily common sense. Right? Contract law is almost entirely based on common sense. Until and unless I'm not sort of standing above you with a gun on your head and say, okay, put your signature on this document or sign away your um, sort of belongings to me. In almost all other cases, if you have your name on the contract, if the procedure in that is followed, the rights have to be enforced. But there are delays that come into play, right? Very often, and much of the litigation here, so we talk about, okay, there's a need to move into alternative dispute resolution. Much of it is government centric, right? The government comes up with these contracts, tenders, right? They award these tenders, and then ultimately the entire payment doesn't go through. What happens? You get into arbitration. Arbitration is supposed to be the shorter process, and not through courts, but through sort of private arbitrators. And that entire process is frustrated time and again, right? Why? Because even post that you get to sort of enforcing those arbitral awards, then the government will challenge it through the court's procedure. What's going to happen? Ultimately, it would have been better if you just went through the court procedure because that entire process is being delayed from time to time. And that's what I say that it's the government's responsibility because bulk of the litigation, right? For those of our friends who are well familiar with how the arbitration practice in India is, um, much of it is titled NHAI versus so and so, right? Or so and so versus NHAI. That's your National Highways Authority of India, right? So because much of the government tender work is through that body, right? And as a result of that, because it's still, I mean, a government body, the bureaucrats and the mindset around it is that, okay, we will face a huge, if we sort of goof up once, they can maybe say, okay, fine, the business was absolutely correct in whatever they did. We don't have to cut their funding, or we don't have to say that they shouldn't be getting the money that they're getting. But they just have to be wrong once. And what's going to happen post that? They're going to sort of lose out on their careers. Right? They're going to be termed as corrupt, even if that's not the case. So even where business is absolutely correct and bureaucrats know that, they still go ahead and say, okay, no, drag them through the litigation. I think in this regard, I think I'm always reminded of the minister's speech, right? This is Sri Nitin Gadkari, right? Who gave this speech, I think, at the opening of this is the opening of an NBCC building, which was again delayed by many years. And he said all of this. He said, I told the bureaucrat to just sanction the letter and just give whatever was the few crores that was due to the builder and the contractor in that particular case. But what happened? The government dragged on through litigation through years, and ultimately they ended up paying 10 times more because of penalties, surcharges, interest, so on and so forth. So the ultimate loss is to the government exchequer always. And this is what happened in the Vodafone case, right? Went through sort of Bombay High Court, the Supreme Court, arbitral awards, everything. What's happening? Now Indian property, whether aeroplanes or hotels on the French Riviera are being attached. Both the Vodafone as well as the KN case and everything that goes in the same sort of bracket of those litigation that came as a result of the income tax uh, the Section 9 litigation that started in that duration, right? And then you had that amendment coming in, which sort of retrospectively uh, amending the law from 62, from when the Income Tax Act comes into force. What ultimately happened? Now, just 2 weeks back, or less than a week back, in fact, when you have the amendment coming in, being proposed, the finance secretary today says that, okay, the lessons were learned post the arbitral awards, but because of our sovereignty, we want to protect our sovereignty and we don't want to sort of enforce those awards against the government. Therefore, the correct way would be to amend the act. And obviously, again, this is not a question, okay, present government, last government. I'm saying that's the attitude of any government, of the bureaucratic machinery. The ultimate loss is not going to be to Vodafone or Kane, right? It's as Mr. Salve says, like, if you are a patriot at heart, if you have India's interests at heart, you would want that these issues not arise, because in the long term, they are going to be detrimental not just to, okay, a government or a party or a bureaucrat, but to the Indian exchequer, right? So that's, I think, important. Very often we think, okay, countries will become stronger if they curb business freedoms. I think that's the biggest mistake. If you look at the history of our times, right? If you look at the Soviet Union, they didn't have an economic base. Because they didn't have economic freedoms. And that's the mistake that China at least has attempted to correct on some stages. I'm not saying they have the ultimate freedoms there either. Right? We've seen this with Alibaba, and we've seen this how it's planning out in China as well. But for a country to become stronger, it has to have a very strong economic base, right? And that's how you strengthen your sovereignty. And to have a strong economic base, you have to have strong economic freedoms. There's no question about it, right? And you can't then tomorrow say, okay, no, we want your investment coming into the country, but we will plead sovereignty when it comes to you getting your due rights. Because Indian companies are given the same kind of status in other countries, right? In terms of the freedoms they enjoy there, the legal freedoms they enjoy there. So when you enter into those treaties with other countries, you have to give the same kind of freedoms to those companies which are investing in. Right? So I think that's again we began on indicators, but like I said, these are the real indicators according to me. Right? At least this is a good step. I still think it's too late. I still think this entire sort of last decade journey shouldn't have happened. And I don't say this as, like I said, this is not coming from someone who's okay, pro business, pro market, right? But this is coming from someone who's generally a patriot at heart, right? I want the best for my country, and it's not going to happen by sort of going through this process of sort of dragging companies, which ultimately will again attach your hotels and airplanes all across the world. Because sure, India might not be enforcing those awards, but France, UK, and other countries most certainly will. Yes.
Right, sir. Actually, very insightful. Food for thought. Thank you. So, one last question here. So, we've been talking about growing businesses and business environment and economic freedoms in general.
Yes.
If we talk more about, say, the economic freedoms and related rights guaranteed to Indian citizens under the Constitution,
Yes.
Are there perhaps any noticeable trends that you've seen in other newer woker rights, like say for example with the penetration of technology you have privacy as a right now that was never
Yeah.
really a hot topic before.
Yeah.
So are there other important trends that we have seen and they'll keep on coming up as well?
Okay. So that's a very interesting question. I don't know how we fit in the words woker in this particular context, but yes, application of the already existing constitutional rights to emerging fields such as technology, etc., is something that is taking place. Right? And I think in this regard, uh, also in continuation of your last question, I think this is a good sort of transition that we had, I think, as one of the indicators which sort of contributes to that rising in index bit. Whether it's being gamed or not is a separate question to this regard. You had the Commercial Courts Act, which is passed, which provides for a streamlined timeline where courts deal with commercial litigation and commercial disputes at a faster pace. There are specialized commercial benches, right? Specifically, and very recently, the Delhi High Court set up its IP division, where the old IP tribunal, which barely used to function over the last years, was done away with after the Parliament brought in the amendment or brought in the new litigation, the new legislation, and the Tribunal Reforms Act was brought in, and the bill was brought in, and the High Court has been sort of working post that. So similarly, you have these commercial divisions in, I think, it's definitely here at the Delhi High Court, and it's in other high courts as well, and there are commercial courts even at the district level, which sort of goes beyond just the high courts in that case. So they sort of move faster. In that regard, what you call sort of worker rights, right? You have enforcing of intellectual property, right? Which again, these rights already existed, right? The Trademarks Act has been the way it has been since 1999. Right? I mean, that's when the Trademark Act was brought in, but sure, you've had amendments here and there. The rights have not changed materially, so to say, but the provisions have been interpreted to apply in the context of the emerging technology. Right? Whether it's advertisements, whether it's Google AdWords. Again, Google AdWords, again, this is something that's sort of pending in courts across the country, across the world, in fact. Right? But when we talk about sort of intellectual property, let's assume that you are running something by the name of, again, by your own, you're running your own product, you're selling your own product, right, in your own company. And we're competitors, we're selling the same product, right? I have a registered trademark, I have a very good reputation. Tomorrow you buy a Google AdWord that anyone who types in Sabharwal products will end up on the first link, which is Mathur products, right? So this sort of litigation developed in this sort of conflict, these disputes developed in the 90s when you had the onset of the spread of the internet and meta tagging back in the day, and then obviously Google took over since sort of the early 2000s and the post.com bubble and all of that. And this litigation shifted from meta tags to Google AdWords attack, right? But courts have been, obviously this particular issue is still being sort of in the process of litigation across high courts and across the courts, in fact, across the world. But similarly, other intellectual property issues, right? We had the Swami Ramdev versus Facebook judgment by a single bench of the Delhi High Court, right? This is, I think, 2019, where for the very first time, High Court order, and I don't think there was anything extraordinary or, as you say, woker in that. I think it was very sound law judgment in the fact that it said that, okay, anyone accessing that from India will not have, shouldn't be able to access it from India, even if it's posted elsewhere. So it wasn't merely what was termed by the media as a global injunction. It was restricted within the territorial jurisdiction in that sense. I think it was absolutely sound in the sense that, okay, fine. It shouldn't be the case that only someone uploading it in India, if at all there is defamatory content. Right? This is not intellectual property per se, right? But I'm talking about the reach in terms of how rights are to be enforced. Right? Sure, this is not economic right per se. This is not intellectual property per se. But I'm saying that that's the direction in which so we are heading, and I think it's a good step in that regard. That rights are enforced uh, proactively by courts. I think in this regard, I would definitely say the Delhi High Court is undoubtedly one of the best courts in the country with respect to sort of enforcing such rights, right? And the same applies to sort of freedom of speech, right? If sure, we're talking about economic rights here, but when we're talking about sort of rights of such nature, they have to include the right to freedom of speech and expression, right? So that is to what is such a right and what isn't such a right. And you talked about privacy as well, right? So obviously you had the Shreya Singhal judgment by Justice Nariman, who just retired sort of 2 days back, and that lays down the right to privacy as being a fundamental right under Article 21 of the Constitution, which again goes with, pardon me for saying, sorry, is the Puttaswamy judgment which lays down the privacy, which lays down privacy as the Justice K. Puttaswamy judgment. It's a 9-judge bench which lays down, which is also 2018, which lays down privacy as the right. The Shreya Singhal judgment, pardon me, deals with Section 66A of the Information Technology Act, which it strikes down, right, which was seen as being violative of Article 19A of the Indian Constitution, as it was violative of freedom of speech, expression, so on and so forth. So the privacy right obviously comes from there. And again, the nature of privacy is such in the modern world where it's actually not about someone sort of going in your back alley outside your house, taking a doorbeen in Byomkesh Bakshi style and seeing what you're doing at your place. The real right to privacy is right here on the phone, right? And so that's where the right has to be enforced, right? So you have the litigation which is also pending against sort of WhatsApp and how its policies are violating these rights. Right? There's multiple litigations pending in the Delhi High Court. There's litigation pending before the Constitution Bench in the WhatsApp matter as well. Right? So these rights are being enforced proactively by courts. Right? It's a positive direction. And again, it's not like new legislation has been brought out by Parliament on any of these counts. Right? Whether it's freedom of expression or sort of property, intellectual property, or right to privacy. All of this is what we call judge-made law, right? It's interpreting the already existing provisions in a manner to say that okay, these rights can be enforced, right? Whether it's privacy, whether it's privacy through Article 21, whether it's 19(1)(a), right? All of these, and whether it's also 19(1)(g) in that regard, right? My right to do business, right? Much of it is um, on the internet nowadays. And I'm reminded of the crypto judgment, right? It was Justice Nariman's bench again, but it was, I think, Justice Balasubramanian who wrote the judgment as in a very sort of what we call a filmy style, right? He says, okay, this is the introduction, this is the intermission, this is the climax. And then someone in the middle, he says, the plot thickens. Everybody's dealing with the RBI circular against the crypto exchanges and virtual currencies are not to be given banking services, so on and so forth. And the Supreme Court struck that circular down. Not on the grounds of, okay, why crypto is to be recognized, not on the grounds that, okay, fine, crypto is, we approve of crypto or not, but on the simple grounds of the doctrine of proportionality, on which, again, there's limited law, like the judge dealt with almost everything else as well. Doctrine proportionality simply says, okay, fine, if the government's coming after me today, the punishment it inflicts on me cannot be more than what is necessary, right? You can't say that, okay, if someone, again, I'm using an extreme example on the other end, if someone who has not had food for weeks picks up a chapati, right? Okay, technically speaking, you will say, okay, this is theft. But are you then going to hang that person to death? Similarly, okay, fine, you may not understand cryptocurrency, or in my opinion, like governments don't understand much of what happens on the internet in terms of commercial activity, right? Their first instinct is to ban it. But courts have said, no, listen, you have to apply the doctrine of proportionality. That, okay, fine. Yes, you can take action, you can place a reasonable restriction, but that doesn't mean you will stand up tomorrow and say, okay, fine, there will be no banking services provided. I'm going to completely ban this. Right. So those aspects, I think the courts have been absolutely open to. They've given a lot of positive judgments in this regard. Those rights have been enforced. And similarly, again, you said we've discussed privacy, we've discussed sort of 66A, 191A, 191G. And obviously, we had this crypto judgment as well. And I think much of it comes through, like I said, otherwise commercial judgments, right, which are dealing with, let's say, a commercial issue, right? But because it's on the internet, because it's on an emerging platform, it leads to what are otherwise your sort of voca rights, right? And that's what leads to the freedom of expression over Twitter. And much of that is still pending in courts. Right? You, Mr. Sanjay Hegde, he's a senior advocate. His account was suspended on account of him putting up something, which is the photo of a person not doing a Nazi salute, whereas everyone else was doing it. But that person, that photo is a famous photo. I'm forgetting the name here. And he was the one who wasn't doing it, right? Which is supposed to be the symbol against fighting against tyranny. And for putting up such a photo, they took it down. Right. So again, this is a clash between freedom of speech and perhaps commercial freedom of those people who say, okay, no, Facebook, Twitter are private companies and they can do whatever they want. So that's where the clash sort of comes in between 19 and ANG to some extent. It's still pending, so I will sort of not get into it extensively. But yes, I think in this regard, especially the Delhi High Court, I'd say is definitely proactive. There's a lot of positive jurisprudence that is being developed in this regard, enforcing economic freedoms, constitutional freedoms over economic and technological platforms. Right. So those aspects, and obviously saying, okay, these freedoms exist, but we are now applying them to the digital domain. So that part is also obviously being enforced quite well. And I think having said that, when I mentioned the sort of Commercial Courts Act, right, what this does is that it obviously reduces the amount of sort of time that litigation takes in court, right? That by itself is a positive step. Obviously, we need to be sort of a lot faster. For example, we had the parliament saying, okay, no, it's within this duration that you complete your entire insolvency process. But then the court said, okay, no, shall here will mean may, or it's like a guideline. It's recommendatory in nature. It's not necessarily mandatory. So that entire process sort of drags on once again, right? So obviously, even from the side of the courts, there's a lot more that's still coming in. Like I said, we have some of the commercial litigation which is sort of moving in a lot faster nowadays. But at the same time, like I said, the insolvency process still requires to sort of catch up in that sense, right? And I've already sort of given you an idea of the sort of relatively voca rights, like I said, which are there, and which is why, going back to my older point, right, that very often we cherish our political freedoms, our freedoms of expression, our freedoms of speech, our freedom to sort of speak against anything that we want to. But very often, the younger generations forget this, and I speak as being part of that generation. That it is not without the economic rights that those rights can be enforced. That's also very important, right? Why? Even the Soviet Constitution had all of these rights on paper. What could you have done? Hired a lawyer and gone to court. Or China, I'm sure, has all of these rights here, right now, as we speak. Can you do that? Why? Sure, China has a component of the fact, okay, they don't have all economic freedoms, they have some economic freedoms, they don't have political freedoms. Like I said, both go hand in hand. So you have to have those economic freedoms to be able to say that, listen, these other freedoms are something that we'll be able to enforce. So there's the right to property and the right to freedom of speech. I'm just sort of broadly saying there are obviously sort of subdivisions and other rights in the larger framework as well. But let's assume you have that right to freedom of speech. Someone bans you. What are you going to do? You're going to hire a lawyer? Not everyone's a lawyer. You're going to hire a lawyer to go file a writ and say, okay, get a court order that says, no, this is my fundamental right. I can say this. And just because I said something against a politician, I shouldn't be put into jail. But how's that going to happen? Sure, there will be some very benevolent figures who sort of do it for free. But at some point, you're going to have to pay something to some lawyer. Right? And I'm not saying, okay, it's the lawyer's fee for which right to property is important. Right? But I'm saying largely, if you look at the largest bench in this country, the Keshav Nanda Bharti case, from which we see all our fundamental rights being protected. To this day, it's called the fundamental rights case, where we get a basic structure where Parliament says that, okay, where the court says that Parliament cannot amend anything and everything that it wants. It was about what? It was about land being taken over by the government. I'm saying it's the fights for these economic rights that leads to a point where you'd say, okay, fine, yes, these other rights also exist. Because to be able to enforce those rights, you have to make sure that there's a base, and that base is always that of economic freedoms and economic rights.
Understood. Thank you so much, sir. So, with this, we come to the end of a podcast today. Thank you so much for taking the time out, sir. And thank you, our viewers, for tuning in. Thank you.
Okay. Bye bye.